In this lesson, we will cover the Georgia Residential Mortgage Act. The overall purpose of the Georgia Residential Mortgage Act, GRMA, is to provide oversight within the mortgage industry by requiring those who work as a mortgage broker, lender, or loan originator to be licensed. The GRMA is governed by Georgia Code Sections 7-1-1000 through 7-1-1021. We'll start with Section 7-1-1002, which sets forth the general licensing requirements. According to that section, you cannot transact business in the state of Georgia as a mortgage broker, mortgage lender, or mortgage loan originator unless you are licensed or registered by the department utilizing the Nationwide Multi-State Licensing System and Registry, NMLSR. There are certain exemptions to this requirement found in Section 7-1-1001. In addition, a loan processor or underwriter who is an independent contractor must obtain and maintain a mortgage broker or mortgage lender license and must have and maintain a valid unique identifier issued by the NMLSR. A mortgage loan originator must be supervised by a mortgage broker, mortgage lender, or exemptee on a daily basis while performing mortgage functions. Furthermore, they must be employed by and work exclusively for only one mortgage broker, lender, or exemptee, and must be paid using a W-2 tax form. Each licensed mortgage loan originator must register and maintain a valid unique identifier issued by the NMLSR. The GRMA also prohibits the purchase, sale, or transfer of a mortgage loan or loan application from or to a mortgage loan originator, broker, or lender who is neither licensed nor exempt from the licensing or registration requirements. Note that a prohibited purchase shall not affect the obligation of the borrower under the terms of the mortgage loan. Anyone who directly or indirectly controls a person who violates the requirements of the GRMA, including a general partner, executive officer, joint venturer, or director of such person, will be held equally responsible for the violation unless they can prove they did not know and, in the exercise of reasonable care, could not have known of the violation. Next, we will cover Section 7-1-1001, which outlines exemptions and registration requirements. There are numerous exemptions to the licensing and registration requirements under the GRMA. Anyone who qualifies for an exemption is not required to obtain a mortgage loan originator, mortgage broker, or mortgage lender license, but may still be subject to registration requirements. Exemptions include 1. Federally insured banks, credit card banks, savings institutions, and credit unions, as well as their wholly owned subsidiaries. 2. A wholly owned subsidiary of a bank holding company. However, a subsidiary is subject to the registration requirements. 3. Registered mortgage loan originators, when acting for any of the entities mentioned in number 1 and number 2 above. However, the individual must be registered and obtain a unique identifier with the Nationwide Multi-State Licensing System and Registry, NMLSR. 4. Anyone who offers or negotiates terms of a residential mortgage loan with or on behalf of an immediate family member. An immediate family member means a spouse, child, sibling, parent, grandparent, or grandchild, including step-parents, stepchildren, step-siblings, and adoptive relationships. 5. An attorney licensed to practice law in Georgia who negotiates the terms of a residential mortgage loan on behalf of a client as an ancillary matter to the attorney's representation of the client, unless the attorney is compensated by a lender, a mortgage broker, or other mortgage loan originator, or by any agent of such lender, mortgage broker, or other mortgage loan originator. 6. A Georgia licensed real estate broker or salesperson not actively engaged in negotiating mortgage loans, who is only providing information to a lender or its agent related to an existing or potential short sale transaction if a separate fee is not received. A broker or salesperson who directly or indirectly negotiates, places, or finds a mortgage for others is not exempt. 7. Anyone performing any act relating to mortgage loans under order of any court. 8. A person, estate, or trust making a mortgage loan with his or her own funds for his or her own investment, including a purchase money mortgage for financing sales of their own property. 9. The United States of America, the state of Georgia, or any other state, and any agency, division, or corporate instrumentality of any governmental entity. For example, the Department of Veterans Affairs, VA, or the U.S. Department of Housing and Urban Development, HUD. 10. Anyone who offers or negotiates terms of a residential mortgage loan secured by a dwelling that serves as the individual's residence. 11. Anyone who makes a mortgage loan to an employee as an employment benefit. 12. Any licensee under the Georgia Industrial Loan Act if the mortgage loan made is for $3,000 or less. 13. Nonprofit corporations making mortgage loans to promote home ownership or improvements for the disadvantaged. 14. An employee of a licensed or registered mortgage broker, mortgage lender, or someone exempt from the licensing requirements when acting within the scope of employment and under the supervision of the mortgage broker, lender, or exempted person. The employee must be acting as an employee and not as an independent contractor. A person against whom a cease and desist order has become final shall not qualify for this exemption, while under the employment time restrictions of subsection O of Code Section 7-1-1004, if such order was based on a violation of Code Section 7-1-1002 or 7-1-1013, or whose license was revoked within 5 years of the date such person was hired. 15. Anyone who purchases mortgage loans from a mortgage broker or lender solely as an investment. 16. Anyone who makes 5 or fewer mortgage loans in any one calendar year. 17. Anyone who would be required to be licensed as a mortgage lender or mortgage broker who is under an exclusive written independent contractor agreement with anyone that is a wholly owned subsidiary of a financial holding company, as defined in the Bank Holding Company Act of 1956, as amended. Bank holding company, savings bank holding company, or thrift holding company if the subsidiary has provided a surety bond equal to the lesser of $1 million or $50,000 per exempt person that provides for full and direct financial responsibility and for the education and supervision of the exempt persons, as well as the handling of consumer complaints related to the exempt persons, and has applied for and been granted a mortgage broker or mortgage lender license, and has paid applicable fees for this license, which shall be the lesser of 1/2 of the sum of the cost of the individual licenses, or $100,000. To maintain the exemption, a person shall solicit, process, place, or negotiate a mortgage loan to be made only by the licensed subsidiary or its affiliate, and remain in compliance with Code Section 7-1-1013 and the provisions and prohibitions applicable to employees under Code Section 7-1-1004. 18. An employee of a bona fide nonprofit corporation acting as a mortgage loan originator only for the nonprofit corporation and who only works with mortgage loans that include terms favorable to the borrower. For a corporation to qualify as a bona fide nonprofit corporation, the nonprofit corporation must meet all the following requirements: be tax exempt under Section 501c3 of the Internal Revenue Code of 1986. Promote affordable housing. Serve public or charitable purposes, not commercial purposes. Receive funding and revenue, charge fees, and compensate employees in a manner that does not incentivize acting in a manner other than in the best interest of its clients. Provide or identify for the borrower mortgage loans with terms favorable to the borrower and comparable to mortgage loans and housing assistance provided under government housing assistance programs. Satisfy the exemption from licensure set forth in number 13 above. Keep in mind that most of the above exemptions refer to exemptions from licensure as a mortgage broker or mortgage lender only. Individuals that transact business as a mortgage loan originator, unless specifically exempted, shall obtain a mortgage loan originator license whether they are employed by a mortgage broker, mortgage lender, or person exempted as a mortgage broker or lender. Next, we'll cover Section 7-1-1003, which outlines the application process for licensure. An application for a license under this article shall be made in writing and under oath. The department may prescribe different classes of licenses for mortgage loan originators, mortgage brokers, and mortgage lenders. An application shall include all of the following: the legal name and address of the applicant, and, if the applicant is a partnership, association, corporation, or other business entity, of every member, officer, and director thereof. All names, including but not limited to website domain names, URLs, under which the applicant will conduct business in Georgia. For mortgage brokers and lenders, the address of the main office or principal place of business and any other office locations, plus the mailing address. Changes must be made in writing prior to that date they are effective. For mortgage brokers and lenders, the complete name and address, which must be in Georgia, of the registered agent and registered office for service of process in Georgia. If the applicant is a Georgia corporation, this registered agent shall be the same as the agent recorded with the Secretary of State. Any changes must be made in writing prior to the effective date. For mortgage brokers and lenders, the general plan, character of the business, and a financial statement, as well as additional information if requested by the department. For mortgage brokers and mortgage loan originators, evidence of satisfaction of experience or education requirements, as required by the regulations of the department. All applications submitted shall be filed with investigation and supervision fees, the items required by Code Section 7-1-1003.2, other information if required by the department. Next, we'll cover the list of prohibited acts as outlined under Section 7-1-1013. It shall be prohibited for any person transacting a mortgage business in or from the state of Georgia to misrepresent the material facts, make false statements or promises, or submit false statements or documents likely to influence, persuade, or induce an applicant for a mortgage loan, a mortgagee, or a mortgager to take a mortgage loan or, through agents or otherwise, pursue a course of misrepresentation by use of fraudulent or unauthorized documents or other means to the department or anyone. Misrepresent or conceal, or cause another to misrepresent or conceal, material factors, terms, or conditions of a transaction that is pertinent to the applicant or application. Fail to disburse funds in accordance with a written commitment or agreement to make a mortgage loan. Improperly refuse to issue a satisfaction of a mortgage loan. Fail to account for or deliver personal property obtained in connection with a mortgage loan, such as money, funds, deposit, check, draft, mortgage, or other document or thing of value which is not the property of the licensee or registrant. Engage in any transaction, practice, or course of business which is not in good faith or fair dealing, or which operates a fraud upon any person in connection with the attempted or actual making of, purchase, transfer, or sale of any mortgage loan. Engage in fraudulent home mortgage underwriting practices. Induce, require, or permit the applicant for a mortgage loan or mortgager to sign a security deed, note, loan application, or other pertinent financial disclosure documents with any blank spaces, except blank spaces relating to recording or other incidental information not available at the time of signing. Make, directly or indirectly, any residential mortgage loan with the intent to foreclose on the borrower's property. For purposes of this paragraph, a presumption of the intent to foreclose exists if the following circumstances can be demonstrated: lack of substantial benefit to the borrower, and lack of probability of full payment of the loan by the borrower, and a significant proportion of similarly foreclosed loans by the person. Provide an extension of credit or collect a mortgage debt by extortionate means. Purposely withhold, delete, destroy, or alter information requested by an examiner of the department, or make false statements or material misrepresentations to the department or the NMLSR or in connection with any investigation. Finally, we'll cover Section 7-1-1014, which outlines disclosure requirements. Certain disclosures must be made to applicants for mortgage loans, including, without limitation, the following. 1. Prior to accepting an application fee or any third-party fees, such as a property appraisal fee or credit report fee, a disclosure must be made of the fees payable and the conditions under which such fees may be refundable. 2. A mortgage lender must provide to an applicant a written disclosure of the fees to be paid in connection with the commitment and the loan, or the manner in which such fees shall be determined and the conditions under which such fees may be refundable at or before the time a commitment to make a mortgage loan is given. 3. A mortgage lender must disclose to a borrower that failure to meet every condition of the mortgage loan may result in the loss of the borrower's property through foreclosure, and the borrower must sign the disclosure at or before the time of the closing of the mortgage loan.